Good day everyone, welcome to another episode in our What If series where we bring you insights in the format of a what if question on the ever-evolving landscape of employment law. I'm VP Moolman from Maserumule, and in today's episode we will unpack what if an employer suspects an employee submitted a fraudulent medical certificate. When can disciplinary action be taken? Now, as you are aware, employers frequently encounter suspicious or fraudulent sick notes, which often prompt the initiation of disciplinary action. Recently, the Labour Appeal Court, in the case of Woolworths versus Maseko, addressed the authenticity of medical certificates, offering valuable insight into the obligations placed on employers in such situations. Now, colleagues, this case concerns an employee who submitted a medical certificate in 2018. The employer, Woolies, questioned its authenticity based on an internal company memo that had raised concerns about the doctor previously issuing suspicious certificates. As a result, the employer launched an investigation into the employee's sick note, uncovering discrepancies between the 2018 note and an earlier one from the same doctor, which note was also submitted by Ms. Maseko. Investigators in this case also visited the doctor's consulting rooms and, based on their observations, concluded that the doctor may not have been qualified and suspected him of selling fake medical certificates. As a result of this, the employee was charged with misconduct for violating company policies by submitting an irregular medical certificate to justify her absence. Ms. Maseko was found guilty and she was dismissed. She then referred an unfair dismissal dispute to the CCMA, and the Commission at the CCMA ruled that Ms. Maseko's dismissal was substantively unfair and held that there was no proof that she was not ill on the dates she provided the certificates. Additionally, the Commissioner found that the medical certificates were valid and regular, as the doctor was a duly qualified and registered practitioner based on the documentation of his qualification and registration. Woolworths, unhappy with the CCMA outcome, took the matter on review to the Labour Court, but the court dismissed the case, finding it without merit. Woolworths then appealed to the Labour Appeal Court and argued that the evidence showed that there were untoward happenings at the doctor's medical practice in respect of the issuing and buying of sick notes. Now, the Labour Appeal Court found no merit in Woolworths' arguments. It expressed concern over the notion that an employee could face disciplinary action simply because an employer suspected the medical practitioner's conduct to be questionable. The court said that under Woolies' own reasoning, a disciplinary process could proceed if the employee was genuinely ill and unaware of any irregularities or illegal activities at the doctor's practice. The Labour Appeal Court then concluded that the key issue was whether Ms. Maseko had visited the doctor on the specified day and whether the doctor had legitimately booked her off as indicated in the certificate. Once this was confirmed, Ms. Maseko had fulfilled her responsibility. Woolworths' dissatisfaction with the doctor's practice and the hearsay about people allegedly purchasing medical certificates were deemed irrelevant by the court. And as a result, the Labour Appeal Court dismissed Woolworths' appeal. Now, colleagues, the key takeaways from the matter can be summarized as follows. Firstly, the Labour Appeal Court found that the public has no duty to ascertain whether a doctor is qualified or not. The right of a doctor to practice is an administrative issue, and the Health Practitioners Council of South Africa should be the body dealing with this issue. The court went further to say that a reasonable or strong suspicion is not adequate to terminate the employment relationship. And then finally, colleagues, this judgment reaffirms the principle that it is not enough to prove that the medical certificate was issued by a non-registered medical practitioner, but what must be proven on a balance of probabilities is that the employee was aware that the medical practitioner was not registered and the medical certificate was fraudulent. So, colleagues, to conclude, for disciplinary action taken against employees in respect of medical certificates to be fair, an employer must prove willful wrongdoing on the part of the employee. Now, this willful wrongdoing can include, for example, that the employee has knowingly obtained and submitted an irregular sick note. Could also include that the employee has tampered with a valid sick note, for example, by changing the date, or it could be a scenario where the employee has pretended to be sick and misled the doctor who issued the certificate, for example, where rather than being sick at home, the employee attends to other matters, which demonstrates that the employee was not ill. Colleagues, that brings us to the end of this week's episode. Thank you for joining us. We hope you found our discussion informative. If you have any questions or comments, we would love to hear from you. You can find us on social media, or you can email me at veerpeer@massconsulting.co.za. Till next time, bye-bye.